We've touched on various topics during the day. You may have heard one or two of them. It's been a long day. I'm conscious this is the last session, but just wanted to sort of end by asking your comments on a few things we've touched upon. We had a session earlier on arbitrations and how useful arbitrations are in pharma disputes. It's said that they could be well suited to sorting out pharmaceutical disputes because of confidentiality issues, and you can select your own arbitrators and there's procedural flexibility. But I don't think we see that much of them, and we certainly don't see them where the validity of patents are an issue for perhaps obvious reasons. Do you think there's more scope for IP lawyers to litigate using arbitrations rather than standard patent litigation?
Well, probably not much. Arbitration in pharma nearly always, well, I've never heard of a case that isn't, pursuant to an arbitration clause in some kind of contract. A joint venture, a licensing agreement are the typical ones. And they can be quite effective there. Sometimes it has great value. I was in one where there was a joint venture between a big pharma and research institute, big pharma, and they were jointly going to come up with inventions, but nobody precisely worked out what would happen if one of them had come up with an invention, or if something was jointly invented by one from each side. There was a huge fight about that, and it was decided they were joint inventors. Well, that wasn't very helpful for the United States patent, which both of them had an interest in. If that had been litigated, third party would have said, well, the patent's wrong, you named the wrong inventors. In the arbitration, subject to a small fight with the arbitral body, they were able to just simply resolve. The arbitrators never gave any reasons, and the case was duly fought on as to what the consequences of joint inventorship were, all of which was kept entirely confidential and very sensible. Trade secrets are particularly good for arbitration because it's much easier to do that. In some countries, trade secrets are not very well protected by court proceedings. They're supposed to be, but they're not. And arbitration is very good for that. But you will seldom see people saying, I've got a fight on here. I'll tell you what I'll do. What we'll do is we won't fight each other country by country. We will get together and have an arbitration, an ad hoc arbitration. I think it'd be quite sensible if sometimes they did. Particularly big pharma against big pharma. Big pharma against generic, no, well, that's probably not really for arbitration at all. That's a fight just about the money, and the big pharma will simply say, well, I'll fight you here, I'll fight you there, I'll fight you anywhere.
How would it work? I mean, if you did have, let's say, one of these brand generic battles on a blockbuster, let's say, something like atorvastatin years ago, one of the big,
yeah,
and it was done by arbitration, and then just before the result of the arbitration, it was a settlement was agreed. Would that be anti-competitive, or would that be?
Well, I don't think so. I mean, it doesn't mean that competition authorities might not get very touchy about it. The concept that in negotiations, one side said, well, I've got a strong patent, and the other side says, no, you haven't, we'll fight about it, and you get an independent third party to form a view. It's not binding, except as between the parties contractually, and only as far as its contractual effect is concerned. And whether the patent's actually valid or not, it remains to be seen. And after all, that happens anyway, even without an arbitration. Somebody will waive a patent and somebody will say, well, that patent's no good. And they do a deal, paying half royalties or something. Is that naughty? I mean,
Robert, I'm reminded of a case that we did, our firm in front of you, and it was a really crap patent, a really weak patent. And I think you described it as the sort of patent that gives the patent system a bad name.
Yes.
I mean, I would have thought if you really have a bad patent and you therefore settle your arbitration to avoid a finding of invalidity, is coming very close to the mark, isn't it, of being anti-competitive? But it certainly could suit both parties if the deal is right.
Well, yeah, but if the prior art's out there for anybody else to attack the patent, that's the position. I think it's very dangerous for competition law to get involved in patents. It's never done any good, really. I think they're wrong in pretty well everything they've done in relation to SEPs, and by and large, they've now backed off. The Germans still believe that competition law is king, but really it's not. It's contract.
Okay, thanks very much. Can we move on to the topic of the moment, that's COVID and patent waivers? I'm not sure if you were in Cornwall a couple of weeks ago with the G7 leaders. I know you're friendly with Boris, but I don't recall whether I actually saw you with him or not. Maybe you were busy with the Queen or Carrie in a but there seems to be a lot of hot air at the moment about patent waivers. I think Joe Biden's on the bandwagon. I think a lot of politicians are. They're saying that agree patent waivers to the big pharma, and then the whole vaccine distribution issue will be sorted out. Is there any truth in that at all, or is it just a complete red herring?
Well, Fanan, she's written that marvelous paper, which I believe you've circulated. And quite apart from that, it's quite obvious that the problem with vaccines is making them. And the patent, nobody's using patents. Nobody's asked for a license, as far as I know. They're now saying patentees, well, we're beginning to appreciate that patents are not a real problem. It's know-how. So you've got to hand your know-how over too. How are you going to do that? I mean, these guys who've got the know-how are busy making vaccines. You don't want to take them off the job. Well, I mean, what could have been done by the G8, say, right, we're going to get 4 billion. The world's population is about 8 billion people. 4 or 5 billion doses is what we need, not a billion, and we will pay for it. And what's more, if you have vaccine waiver, the incentive for the future for vaccine research disappears. If every time you need a vaccine, you say we're going to take your patent rights away, so there's no point in it at all, and it's very dangerous. And it is the old notion that patents are bad ideas, and it goes right back to Jeremy Bentham, 1792. If you don't understand patents, you think they're a bad idea. Once you understand them, you think they're a good idea and should be the subject of property. That's what he said.
Do you think politicians generally don't understand how patents work?
Yes, absolutely.
They're usually intellectual property ministers and things. I don't know who the current one is. I think Lord Sainsbury may have been one many years ago, and I can't remember who the latest one is. But I mean, are you consulted by government from time to time? Because you would be the obvious person with your background in the judiciary and academia. I mean, surely they need people like you to advise.
That sort of thing, not consulted. I mean, I've just done a review of the Patent Office Tribunal Service at the request of the Patent Office. But no, they don't consult that way at all.
But they have all these spans and these advisors. Kate Bingham was the vaccine lady, wasn't she?
Yeah, well, she wasn't an advisor. She was invited in, asked to come in, not so much invited. She didn't really want to do it. Whitty was the one who proposed her, and it probably helped that her husband was a Tory minister, but I don't think he had anything to do with it. And she did the job. I mean, she's the daughter of the great Tom Bingham, so
that's right.
There's no dodgy goings on there.
No, damehood as a result, so everyone's happy.
Yeah, I mean,
it does seem a bit facile, some of the comments made about patent waivers, and there was not editorial in Nature recently, which is obviously a very highbrow journal, saying patent waivers would be the answer, and it just does seem to completely miss the point. And you think if they speak to a couple of patent judges or relevant people in the business, they'd cut through it and realise that, as you say, it's a distribution issue.
I mean, some of the anti-patent brigade, Jamie Love in America, who's been against patents for years in pharma, he's realised that actually you've got to do something about the know-how, otherwise it doesn't get anywhere. And there's no power to order somebody to tell somebody else how to do something. That's not a waiver. And on top of that, in fact, it's very difficult to make these. Even the people who are good at making it find it going wrong. These are big molecules. These are complicated organic molecules, and some of the problems are nothing to do with the patents at all. It's supply chains.
Let me turn. Thanks, Robin. Let me turn to the another topic which I think we've discussed earlier today: the Regeneron and Kymab case, which was a very complex case, where I'm not sure whether you agreed with the Supreme Court decision, but it was obviously very complex, very, very difficult. I mean, do you think the courts are in a position to handle cases with very complicated technology like that? And do you think they have the necessary reliefs available to make the right orders, or do you think there needs to be further reform?
Well, I think Kymab was plainly wrongly decided the way it was. There is a possible justification for it, which I'll come to in a moment, because that's you're asking two questions. One is about whether Kymab was okay, and the other is about high-tech cases. I think the courts can cope with high-tech cases. I found in the Court of Appeal, I had two cases where I wanted a scientific advisor, and of course Lenny Hoffman got one in Biogen.
You got one in Amgen, I think, as well, didn't?
Or was it Amgen? It may have been Amgen. Maybe
yeah.
Amgen. Yeah, it was Amgen. And they got a teach-in. And I think that's the best we can do. I mean, but it does work. In the case I was concerned with, and nobody understood the technology. I always thought it was quite a good idea to get, as a scientific advisor, somebody who really wasn't a very big wheel. I mean, some scientific advisors sat there telling the judge what to do. We've had dinner with one of them, haven't we, Simon? My scientific advisor in the Court of Appeal, I didn't even know what he thought about the case until after we'd given judgment. And he told me afterwards that he thought it was obvious, but originally, but by the time he'd heard the hearing, he thought it wasn't. And that was technic. Not technic. The one about finding oil under the sea. Come back to me in a second. And he was really helpful. Only two groups of people in the world understood it. And Blanco, years ago, when they first started trying to use a scientific advisor about colour television, and they got a chap, the head man from the BBC. Blanco was proposing they use somebody from the patent office. And I think a patent office examiner could be really helpful, but I've never seen one used. And the one in this oil case, the patent office said they hadn't got anybody who understood it.
Does it ever happen that a judge in a patent case just doesn't really understand the technology well enough to make a decision, and it is just having to cobble something together? I'm not talking about maybe specialist judges, and I'm not just talking about the UK, but you must have seen it, maybe in the Court of Appeal when you sat with two other judges, or when you're in charge of a list in the High Court. I mean, it is pretty complicated technology. It's pretty varied, and unless you've got a good grasp of the technology, it's pretty difficult, isn't it?
Well, I mean, an American jury will decide whether a patent is obvious. So it's reduced to a very low level. American judges all say it's wonderful, but I don't think the rest of the world does. And I agree, sometimes it's pretty hard to get on top of the technology. But that's what barristers do. They get on top of technology in all sorts of fields. Construction cases where there's allegations of something defective going on, it may be very high tech.
Well, yeah, I mean, the barristers are in a better position. The lawyers are in a better position because they're usually technically qualified. I'm talking about judges who may have never heard a patent case before and don't have any technical qualification.
It's a problem. Then it is a problem. That's why there's over the last 50 years, there's been increasing tendency to create specialist patent courts. And it's happened in lots of countries. It's happened in France. You have a specialist patent division. Before that, you could start a patent case anywhere in France. Now you have to start in Paris, and there's a group of the younger patent judges in France, pretty good.
Yeah. Okay.
Germany has been specialist for a long time. Sweden.
Yeah.
So,
Robbie, when you were at the bench, you were known as the great great reforming judge. You were the one who, I mean, I remember at the start of my career, patent cases were 4 weeks. So you had all evidence in chief and loads of disclosure, discovery. You changed all that. Looking forward now 10 years, what are the big things that you think need to be changed now? I mean, one of the things that people often mention to us are the vice of divisionals. And there have been various cases where people have let one parent lapse and a divisional emerge and enforce the divisional and that sort of thing, which can be problematic. Obviously, depends on which side of the industry you're on. I mean, another thing that strikes me is the European Patent Office is still incredibly slow, isn't it, to get resolution? Although incredibly important compared to the UK High Court can come to a decision if it needs to in 6 months. The EPO can take 7 or 8 years. What if you had a wish list of things? What would you set about changing? I know you've got the UPC as well, and you may like to comment on.
There's a bunch of things. I think probably the most important thing is the SPC regime, financially, and far as Pharma is concerned. That's the really big thing. The SPC system is completely hopeless. It's intellectually dishonest and unintelligible. It was created by the Commission, who didn't understand either regulation of pharma or patents. And very comically, they thought it was going to be very simple. It's actually in the pre-document saying this will be very simple, easily administered by patent offices. They had no idea what they were doing. And it was created because they didn't feel they had any powers over patents. So they created this separate sui generis right. Because what we had before was just straightforward patent extension, which was a very effective system. I'd like to see that come back. You just see how much money they made from the patent, what delays there were, and simply give an extension.
And the IP office, the patent office would determine that, would they, in the first instance?
Yeah, well, you could under the system which was around when I grew up, they didn't have jurisdiction over patent extension. It was dealt with by the court. War loss could be dealt with by the patent office. I did a war loss case, and we even ended up in the divisional court with we'd asked for 3 years, but the arguments weren't run so well. The office gave us more than we'd asked for. And somebody said it was a virus.
Right.
I do think it would be sensible to do that. There aren't so many SPC cases that this becomes unworkable, get overloaded or anything like that. If it was done instead by just patent extension, and it saves so much complication.
Yeah. And what about the EPO? I mean, is that? I mean, you must have links at the EPO. I don't quite know how it works, who controls it, who governs it. But I mean, it doesn't. I know there are some changes, aren't there? They've been doing some video hearings in the pandemic, and they've changed the rules on division.
There were several things that were wrong. I mean, there's 2 areas wrong. The worst is the opposition division. There's not a full understanding that an opposition is actually litigation. They say it's administrative, and they think that they're really still carrying on examining the patent. They're not. They're deciding a fight. So I would like to see that made plain, and that the opposition, the board, consists of people who were not the examiner. The examiner's always there's a sort of, he's going to want to uphold what he did before. So I'd like to see that just as a system where it's regarded as judicial. It is very ponderous, and for a long time, you got an extension on the ground you asked for it, which is not a good way of doing it. This was true in our patent office under our opposition system. And you've got to find a way of speeding it up in the cases that matter. You've got to realize that a lot of oppositions don't matter. And probably if you abolish the 9-month period where you've got to enter into opposition after grant, you would get a decrease in opposition. That's what happened in UK. When we abolished section 14 of our Act, which provided for opposition, and there was an opportunity of doing something called a belated opposition within 1 year of grant. When we abolished that, the Patent Office thought they were going to be flooded with work. And the precise opposite happened. They trained up all sorts of superintending examiners to take all these massive cases, and they just dropped away. And now there's virtually no revocation work in the office at all.
So is that because people want to file to protect their position? They filed an opposition because they had that 9-month deadline, and then just fought it because it sort of trundled along.
It trundled along.
That deadline, they could just see whether commercially it made sense. I mean, that sounds very sensible to me.
It would be a bold move. I don't think anybody would understand it. I mean, because people don't learn from experience. What happens when you abolish a time limit? Well, we've got a very good example in the UK, and the answer is you get rid of the work. The other thing which they could do and should do is to realise that this shouldn't be dealt with as a sort of administrative task. You just work, taking each file from the end, working your way through that one, then take the next one, and the next one. Most patent oppositions don't matter. And what you need is a good system for saying, well, this one matters, and we put the gas on this one. Now, they've done that to some extent for the boards of appeal, but they haven't done it really for the opposition. And that would change everything too. If you really could say, right, this is commercially matters, and we want a result, and we need a result now. I mean, you can speed things up. We do that with our courts. So the concept of an application for expedition is quite unknown in many parts of the continent. So as we just do it. Yeah. You're talking about the fastest case that was ever done was it went from issue of proceedings to decision in the Court of Appeal in 2 months. How about that? It was a very easy case. It was about a plastic tap for a wine box.
But even so, staggeringly fast. Why have the UK judges never got involved in sitting as EPO Board of Appeal members?
They do.
There's that Christopher Rennie chap, wasn't there?
Oh well, Christopher Rennie was a Board of Appeal member.
Yeah, but I mean, I can't. How many UK judges have?
Well, the judges. There's always a UK judge who is an external member of the enlarged Board of Appeal. I don't know who's got it now. I think it was Colin. It was Nicholas Pumphrey at one point. I never did it.
Right.
And they have an external judge. And I'm getting it's a very odd system. They've got external judges from every member state. They have to. And you don't sit on every enlarged Board of Appeal case. Nicholas did sit on one at least, and I think Chris Floyd did.
Okay, we're coming to the bottom of the hour, I think they say, don't they? So we're coming up to our time. I don't know, Adrian, whether there are any questions that you've got or that any members of the audience have got, but I think we've covered most of what we wanted to cover. Anything from you, Adrian?
That's great, Simon. Do we have any questions for any of the attendees, any of the delegates?
Yeah, I have one for roping. Coming back to the patent waiver, do you think to what extent this will become true?
To what extent will it?
It will be adopted.
It may never happen. In some ways, I sort of hope that it does happen, in a sort of perverse way, because nothing will happen as a result of it, and people might learn the lesson that this sort of nonsense doesn't work. But I think it might. The downside is really the effect on investment. I mean, what has made this pandemic is manifestly clear is that we need masses of investment in vaccine making, vaccine research, and how we're going to respond to the next pandemic. We've got to look. The whole system has got to be tarted up, really.